So, good morning. My name is Stefan McDaniel. I'm at Notre Dame Law School, a visiting assistant professor, and it is my absolute privilege to act as moderator for this distinguished panel. Disagreement among citizens on extremely important issues is common and can be highly problematic politically and legally. Some very well-known areas of disagreement involve what in the U.S. we call the life issues, disagreements surrounding the transmission, preservation, and ending of human life. This can become a serious political problem when the state does not only permit, but guarantees access to procedures somehow affecting human life that some citizens, including some medical professionals, consider immoral or even sinful. So in those cases, can the state avoid the choice between crushing consciences and breaking promises? Are exemptions justifiable? Are some mandatory? Who should be exempt? What are valid grounds for exemption? What are the limits of exemption? These and other questions will be discussed by our panelists, our very distinguished and very Italian panelists, whom, well, we are in Rome, yeah.
We had also the lecture in Mass in Italian,
yeah,
because there was no English translation.
Yeah, that's right, yeah. It is Rome, when in Rome. Laura Palazzani is a professor of law at LUMSA University here in Rome. She's a member of the European Group on Ethics in Science and New Technologies in the European Commission, the Committee on Bioethics of the Council of Europe, and of the International Bioethics Committee at UNESCO. She's an ordinary member of the Pontifical Academy for Life, has served as Deputy Vice Chair of the Italian Committee for Bioethics. Her research focuses on life issues, beginning and end of life, clinical trials, informed consent, emerging technologies, enhancement, pandemics, philosophy of law and biolaw, and gender theories, probably also, jazz and economics, I don't know, Lorenza Violini is professor of Italian and supranational, not supernatural, public law at the University of Milan. She has, she's the president of the Intergovernmental Commission for Agreements with Religious Confessions here in Italy, and permanent fellow of the Center for Ethics and Public Policy and Culture, at Notre Dame. She writes extensively on issues of public law, European and Italian public law. And has written extensively as well on issues of fundamental rights. Finally, Andrea Simoncini, who is currently the director of the Department of Legal Sciences at the University of Florence. He teaches general constitutional law, the constitutional law of technology, and artificial intelligence law. He has been a Fulbright Distinguished Fellow at Notre Dame Law School and Permanent Research Fellow at the Center for Ethics and Culture and Distinguished Research Affiliate at the Kellogg Institute for International Studies, also at the University of Notre Dame. His research interests range from issues related to Italian and European constitutional law to the sources of law, the relationship between technology and constitutional rights, environmental law, social rights, and the relationships between natural law and positive law. So these are all very, very qualified panelists to discuss the issues we just raised. I will just let the panelists present for 10 to 12 minutes, and then we'll take questions from the audience. And without further ado, Professor Palazzani.
Thank you very much, Stephen, for this introduction, and thank you for inviting me to this very important panel on bioethics. And I was trying to find the best topics to talk with you on this question of religious freedom, and I was thinking about consensus objection, because in bioethics, you all know, we face an enormous quantities of ethical questions arising from the fast and rapid and complex development of technologies. We have a huge range of possibilities of intervention on human life, and I mean manipulating human life, modifying human life, and also eliminating human life. Think about reproductive technologies, genetic engineering, gene editing, euthanasia, assisted suicide. So we have a lot of questions coming out from technological development, and we live in a very pluralistic society on an ethical point of view and on a religious point of view. That's why it's very difficult today to elaborate laws in bioethics. That's a very difficult relationship between bioethics, being pluralist, and biolaw, trying to find legislations and rules that discipline the behaviors of all the different citizens. What about ethical pluralism? We range from libertarians, who are talking about individual rights, self-determination of moral agents, going through utilitarianism, talking about convenience, maximization of pleasure, minimization of pain for greatest number, and going towards personalism, which is a theory just putting at the center human dignity and common good. So we have very different views, and it's very difficult to try to combine all the different perspectives. And that is also the role of the bioethics committees, that is on a national level, as in Italy, but almost in every country of the world, except USA, because you don't have a presidential committee for bioethics now. But we have a lot of committees also at continental level, in Europe, for example, at the European Commission, at the Council of Europe, and we have also bioethics committee on international level, as at UNESCO. What is the role of these committees? Is to try to discuss all the different topics on an interdisciplinary level and pluralistic level, in order to find, whenever possible, sort of conciliation, mediation of the different ethical values, in order to recommend to the parliament or to the legislator the possibility to find a law. But sometimes it is not possible. And so that's why we need, in a lot of different bio-legislation, I may say, consensus objection. What is consensus objection? It's not so easy to find a very, very general definition. Anyway, consensus objection is the possibility to dissent and not to obey to a specific law, I mean law issued by the legislator, so positive law, we all call them positive law, and in order to act and to behave according to the moral law or moral values. So the difference between external positive law and interior moral value. So consensus objection is very important in order to guarantee the freedom of conscience. And I mean conscience on two levels, not only the freedom of thought, of expression of our thought, but also the freedom of behavior coherently with thought. So consensus objection is the possibility that can be guaranteed by a law in order to be free. But, and that is a problem, we have two different meanings of consensus objection, and you find these two different meanings also in Dignitas Humanae. The first is the subjective meaning. So the idea that consensus objection is the possibility to express his or her own will in a very subjective way. So defining as moral agents what's good, what's evil, and just to have, I would call it a consensus option, not objection, but option, in order to express our will. Consensus objection may have a very different meaning that to me, is the most important, meaning that is the objective possibility to express objective recognizable values. For example, human dignity, the common good, as the true and just, we may say, values in our society. In that sense, consensus objection is a sort of witness. So we are just going to express not only our will, but our rational recognition of objective values. And that is the meaning we have of consensus objection in Dignitas Humanae. You see, there is a rejection of consensus objection as a subjective disposition of a person, and there is a mention of consensus objection as awareness, responsibility, duty in the recognition of human dignity and common good. So, what is the consequence in the bioethical field? It's not so easy to defend consensus objection in a law in bioethics. There are a lot of theories, I may say at least one theory, that is the one of the libertarians, who are against consensus objection because they find it incompatible with the medical profession. So this perspective of a so-called incompatibility, they think that if we have a law recognizing individual rights, think about abortion or euthanasia or assisted suicide, individual rights, they say this is incompatible with consensus objection of physician because there is a sort of contractual relationship between a physician and a citizen, and if it is recognized in that state, in that country, an individual right, the physician is obliged to serve and to execute the will of a citizen. So, no reference to consensus objection in a law on abortion or euthanasia or assisted suicide. There's a strong movement against, because they say otherwise, if we recognize consensus objection, we produce inefficiency in medicine, because the individual rights cannot be promoted. On the other hand, we have another perspective that is the one of compatibility, that says that laws should recognize consensus objection because the physician needs to be free to express his or her own perspective when it has to do with the human dignity. That is not only something that has to do with Catholicism, but it has to do with deontology. The physician needs to cure and care for the patient. It has to do with philosophy and personalist philosophy that focuses on human dignity and has to do also with legal and juridical level, because we have a lot of documents also in bioethics just putting at the center human dignity. Think about Oviedo Convention in Europe, but also the Universal Declaration of Bioethics and Human Rights that was approved by UNESCO in 2005. So, in the Italian Committee for Bioethics, we approved a document that was voted by a majority of the members of our committee I need to talk on the past, it was pluralistic, and on a majority we approved the document saying that consensus objection needs to be recognized in a law in bioethics because of a pluralistic society. Only when the first requirement is when there is an objective relevance. It means not only a subjective request of a will, but when there is an objective relevance. I mean, when human dignity is at stake. Think about abortion. when we have the human dignity to be recognized by the fetus. Think about euthanasia and assisted suicide when you have the human dignity of a terminally ill patient. Thank you very much.
Thank you very much, Professor Violini.
So thank you very much to the invitation to this panel. Thank you, Dean Cole, for the invitation, and to the university for being so open to listen also to the people coming from this land. Thanks to the previous person, thank you to Laura too, because she gave me the opportunity to skip some premises which I was ready to give it to you. And let me enter directly in one situation that gives you also the concrete problematics that arose from conscientious objection. So in Italy, let's start with the Italian legal system and stay by the Italian legal system. It is important to underline that conscientious objection is not a right specifically recognized by the Constitution, but it has rather developed over time according to modification in the cultural and legal environment of society, which give us a first idea about conscientious objection, meaning that the culture is important, the environment is very important. If people are aware that they can refuse to take some to do some services and because it is against their conscience, this is a prerequisite to have then conscientious objection legalized. And in fact, in Italy, the conscientious objections arose from opposition to mandatory military service, not in the area of bioethics. And then the Constitutional Court recognized the right, and the legislator passed a law in order to regulate over the matter. Therefore, we have to go back to the Constitution and to several values stated in the Constitution. Article 2 about fundamental human rights, but also freedom of religion and freedom of speech, as it is normal. It is also useful to specify that there exist cases in healthcare in which religious beliefs play a prominent role. For instance, we know that Jehovah's Witnesses refuse to accept blood transfusion on religious ground. And this is an example of it is so problematic sometimes to rule over the matter. In the area of abortion, two are the main laws in the Italian legal system about conscientious objections: the law on permitting abortion within the first 3 trimesters, and in some cases even further, and then the law of medically assisted procreation. What can a person do when they want to manifest objections to some practice? They can, of course, refuse to perform abortion, but they can also refuse to certify the status of pregnancy and to certify of the existence of the pathology that may seriously threaten the physical or psychological well-being of the woman, therefore allowing abortion beyond the first trimester. So sometimes you can even refuse to certify status facts, and this is considered an important part of your freedom of conscience. And then the law is tried to be very specific in regulating what you can do and what what you cannot do. For example, the exemption in the area of abortion applies only to the activities specifically and necessarily directed to interrupt pregnancy, and not to any kind of assistance before or after the abortive intervention. And then, if a person wants to object to some practices, they have to say this preventively, so that, and this is very important in the area of balancing different interests, as it was mentioned before, so that the healthcare officials can replace him or her and guarantee the performance of the activity, which is a specific rule provided by law. But this is not all. There are many cases brought in front of courts, people willing to present conscientious objections, and they were not permitted by their officials. For instance, cardiologists did not want to perform ECG, which is important for the intervention, but the court refused to accept these objections, and he was condemned for neglect of duty. And also other obstetricians were condemned because they refused to prepare the sterile area in order to perform interventions. And the judges were, in a sense, very reluctant, say, to have a broader interpretation for the law. In one case, conscientious objections were allowed because the order to perform a test did not specify if the procedure was in the direction of abortion or in any other procedure. So judges are, let's say, sometimes strict, but sometimes also open to enlarge the area of conscientious objection. And also judges can have tried to refuse to certify for underage girls, underage women, to have an abortion, but all the courts were very strong in saying no. If you are a judge, you have to follow the law, and you are not allowed to refuse this to take part in the procedure. And sometimes we have also very trivial cases where the pharmacist, for instance, refused to sell an abortive drug, but of course this is, is not a big harm for society, because you can go to the next pharmacy, which is for sure not very difficult for people who wanted to have such a type of drugs. So, going to the conclusion, and to make a long story short, so to say, the title of my presentation was Conscientious Objection Under Attack, and this is why we have to pay attention to this, because the attack can come from different parts, from different groups, from different movements, sometimes due to the law which is not properly framed, or to the judiciary which is working against conscientious objection. But sometimes it's also a matter of ideological opposition to conscientious objections. For instance, recent data collected by the Parliament for the Parliament to the Ministry of Health in 2022 revealed that over 64% of gynecologists in Italy are conscious objectors. And so there was a lot of discussion by people who wanted to abolish conscientious objections because that impairs the performance of healthcare. But this is really wrong, in my view, because the law specifically says that conscientious objections is a right, and the officials in the healthcare system, have to provide a substitution for people that do not want to perform abortion. Thank you for your attention.
Thank you very much, Professor Violini. Professor Simoncini is going to throw us a little bit of a curveball. We're going to bring in big tech. Watch out for this.
Yes, thank you so much. So first of all, let me join Lorenza in thanking Professor Cole and the University of Notre Dame for this invitation. It's always a great joy, great pleasure for me to see such distinguished group of colleagues, but if I may say, a lot of friends here. So thank you for this opportunity. As Stefan was saying, the title of my brief presentation that I chose is Religious Freedom, Bioethics, and the Rise of Algorithmic Society, because it's something that I'm studying in recent times. And I would like to share some thoughts with you, starting from two questions. The first one is, what do we mean exactly by the expression religious freedom? Because I think that sometimes we misunderstand a little bit this expression. Obviously, we move from, for example, Article 18 of the Universal Declaration of Human Rights, that similarly to a lot of national constitutions, says that religious freedom is, quote, freedom to change or to manifest his religion or belief, either alone or in a community, in public or private, in teaching, practice, worship, and observance. And following this notion, as we heard before in the panel, a good indicator of religious freedom can be considered how many different religious orientations, confessions are freely practiced in a given country. And this is obviously true and right. But I think that this definition doesn't encompass all the possible meanings for religious freedom. I think that there is a deeper and wider idea of religious freedom beyond this one that is extremely interesting to explore today, especially for the challenges that, as far as bioethical questions are concerned, the challenges that can be on the table from the rise of what I try to define as algorithmic society. To understand better this broader idea of religious freedom, I would borrow a passage from the message of Pope Benedict XVI for the 2011 World Peace Day. The right to religious freedom is rooted in the very dignity of the human person. Religious freedom is at the origin of moral freedom and should be understood not merely as immunity from coercion, but even more fundamentally as an ability to order one's choice, one's own choice in accordance with truth. Pope Francis recently reinforced, reason recognizes in religious freedom a fundamental human right which reflects the highest human dignity, the ability to seek the truth and to conform to it. Religious freedom is not only that of private thought or worship, it is the liberty to live both privately and publicly according to the ethical principles resulting from truth. In this broader sense, that also we heard from the words of Professor Cole in his introduction, religious freedom designates a sort of two-dimensional liberty. Firstly is the freedom of asking questions in front of reality, questions that can have either pure materialistic or transcendent answers. And secondly, and together, is the freedom of living individually and collectively according to those found answers. So in this perspective, a good measure of religious freedom is not only how many religious confessions you can have, but before all of this, how individuals and societies are free to experience their lives, to imagine answers to the questions coming from that experience, and to live accordingly. So second question, what is what I call not only me, but algorithmic society? Trying to synthesize a very complex issue, I think that today we live in a society that is increasingly dependent on technological devices, and this is nothing new. Since the invention of writing 4000 BC, human evolution has been deeply shaped by technology. However, I think that if we consider the last 50 years, two factors seems to be truly exceptional. The first one is the dependence rate on technology is becoming greater and greater. Think simply of the present situation on energy here in Europe as a result of the war Ukraine-Russia. A growing number of technologies are becoming life conditionals. The second, and this is I think really unprecedented. The second factor is related specifically to digital revolution. Because digital technologies are not only pervasive and increasingly addictive, but they do have a direct impact on our moral freedom. To better understand this point, I think we should move back to the classical ethical paradigm that framed somehow our bioethical and legal mindset since Aristotle. The idea that technology, is a means, is an instrument to carry out human decisions. Coming more specifically to our topic, there is a specific feature of what we call algorithmic society that I think could be useful to highlight. 5 minutes, really? Okay.
Oh, really?
The question is this, that until now we use technology to carry out what we have already decided to do. So technology is a way to do quickly or more efficiently what we decided to do. Today we increasingly use technology to decide, to take decisions. And this is what I call the moral impact of those kind of technologies, mainly on our young generations, but I think that this is a growing effect. I don't know if you are familiar, so in which way we ask technology to decide. There is an explicit way, a direct way. You ask which is the best way to go to Piazza della Conciliazione, and you use an app, probably. And we are growingly dependent and addicted to those apps. But there is another, more subtle and probably much more effective way of depending on technologies. That is, technology, it provides us informations. If you ask yourself, which is the usual way to take information, to get information on what to do today, until some years ago, you probably said that education is the way through which person is introduced to the knowledge of reality. But today there is a huge role of those platforms that are providing information. And this is the most effective way to affect our behavior, more than probably simply asking to decide on our behalf. So I think that putting together, I would like to quote an interesting experiment that is the moral machine. I don't know if you are familiar. It's from MIT, in which is a website in which you are presented with different scenarios, in which a driverless car has to decide exactly to kill a pedestrian that unexpectedly crossed the street or to turn out, and you have to you are put in front of this and you choose. The idea of the designers is to build a crowdsourced picture of human opinion on how machines should make decisions when faced with moral dilemmas. And my fear, what I'm afraid of, is that obviously this is some sort of play of something that is clearly said as an experiment. But it's sort of symbolic way of saying that given a certain number of data, given a certain number of computing power, we can also ask machine to solve moral dilemmas. So, concluding, I think that today there is a big risk for facing what I call the rise of algorithmic society. That is to create a sort of new kind of anti-religious society, a society in which religion is not only attacked in its core sense, as we heard before in the panel before, that is explicitly attacking the religious expression. But there is a sort of more deep or deeper way to interfere with the freedom that is intermediating our experience of reality and providing information and solutions and answers to the questions. Think about the echo chambers or filter bubbles question. That is, if the more we use technology to be informed, because algorithms that provide information, they are designed to maximize our online experience. You are provided only of information that tend to reinforce, to confirm your previous ideas. And I think that this is, at the end, a risk for religious freedom. Religious freedom, I think, in this sense, because here we have in front of a great initiative on this, I think that must be considered in this broader and holistic way, saying that religious freedom in a broader sense could be a wonderful antidote to the risk of this sort of digital autism. The capacity of humans to experience real life, to find answers to the questions triggered by the experience of life, and to live according to those found answers is more than ever a basic prerequisite for all freedoms, as we heard today. I understand even better why, not only in the church doctrine, but as always, this idea that religious freedom is at the grounding floor of all the other freedoms, because it's the freedom of finding answers and living accordingly. While I think that this intermediation of technology is a risk, I want to be clear. I'm not against technology and technological evolution. On the contrary, I think that we need to embrace all those positive results and transformation, but without giving up our critical reasoning. And to quote a recent European legal document on this, the future for our societies, the critical challenge is to promote a human-centric technology. That is a technology that doesn't substitute human freedom, but help and support it. And now I'm stopped not by technology, by him.
Thank you very much. Before taking questions from you all, I want to ask the whole panel, but especially the bioethicists, whether, as Professor Simoncini suggests, religion really is special in this particular context. Conscientious objection is certainly not limited to objection for religious reasons. Is there a reason to give enhanced protection to religious reasons? I'm sorry. Sorry, yes. Is there a reason, I'm asking the panelists if there's a reason to give enhanced protection or in any way treat differently religious reasons for objecting to, for example, abortion. For example, I understand that in Italy, to make this more concrete, conventional wisdom has it that you are allowed to conscientiously object to medically assisted procreation because there is a risk of killing embryos or embryos not growing to development, but that is because there is a publicly recognized value that could be understood in purely secular terms of human life. If your objection, however, is based more firmly on specifically religious doctrine, that this is, say, on a Catholic point of view, it is improper and immoral to procreate outside the context of ordinary sexual relations, that would not be a legitimate reason. So that would be one example of where it might come down to brass tacks. So bottom line, should religion be special, religious reasons be special in conscientious objection?
So one example is, I totally agree, the one on procreative liberty, but now we are discussing in Italy also the question of assisted suicide. It's just in discussion now at the parliament. And so there is a strong movement against the recognition of consensus objection, just saying that if we pass a law that recognizes the individual right to receive help in assistance, medical assistance in suicide, there's in no way the physician can object. So the physician cannot say, no, I do not want to help someone to die. And there's a big discussion, libertarians are against consensus objection, and also some political parties. For example, the Radical Party is against consensus objection because they say if we recognize consensus objection, we cannot guarantee to the individual to receive assisted suicide. We may have a scenario where all the physicians object to assisted suicide, just saying that we want to as Hippocrates said many centuries ago, we want to care and cure the patient, not to help him or her dying. And that is one question. And I think there is a big contradiction in this rejection of consensus objection, because it is the theory that says that liberty is at the center, but they want to protect the liberty of the will of individuals, and they don't want to protect the liberty of the physicians to say, no, I do not want to help someone to die. So I think there is also a philosophical contradiction in this request.
So, thank you for your question, Stefan. No, the answer is, in my view, no. There is not a specific status or for religious ground to give the possibility to persons to object. And this is a very healthy, let me say this, approach to the matter, because it is very important that the state does not ask you to express the reasons why you object to such a rule, such a duty. So the reasons about your objections are protected by the legislator, and the only way to see if this objection is sincere is if you are caught to perform privately an abortion, and then it's of course very clear that you are not sincere in. But I think this is a very important aspect of the conscientious objections. The only way for state to balance different approaches to this is to provide substitutes for people in order to have other physicians, to hire other physicians to perform abortion or any other, and not to distinguish between religious way to ground your objections, because this could be very dangerous for the intimacy of the people.
With that, we can start taking questions from the audience. I think the mic's going to come around. Sorry.
Okay. It seems to me that an emerging issue that's important in the context of bioethics for all of us is the transgender issues and the ramifications for conscience exemptions. And I'm interested if the panel could touch on this in three particular ways. One is parental rights with respect to that issue. But the other also is for medical students in multiple countries, as well as practitioners opting out of mandated participation in these treatments.
Professor Violini.
Yes, thank you for raising the issue. And in fact, this issue is not yet discussed in the public opinion. It seems pretty normal that people can do these treatments, and they are not. There is no discussion on the matter. But I think it's very important to raise the question, even only when, in fact, this would be provided by the public service through taxpayer law, which is, of course, something that is basically for creating a duty for the practitioner, for the physician. Up to now, it's something very subtle that runs underwater, and we have not put any discussion on the matter. Thank you, anyway, for raising your question.
There is a big discussion in the Council of Europe on intersex children. Maybe you were referring also to this discussion. So the idea that some babies can be born with ambiguities in the sex. Well, so there's no real clear differentiation of female and male. And so there's a big discussion saying that if we have these children with sexual differentiation disorder, we need just to accept them because they are intersex. That's a new category, just neutral in between female and male, and say we accept that. We don't need to change the sex, normalizing, so to say, the sex, but just accept. So we need to change society in accepting intersex children, and there's a big movement in favor of gender movements, so ideologies, gender, just saying we need to to accept this so-called neutral gender. And there's a big discussion. We discussed it in the Italian committee, just saying that we want to use, and it was pluralistic, the national committee, just saying we want to use the medical terminology, and the medical terminology is differentiation, sexual differentiation disorder. Disorder is a pathology, and we need to treat them. But there's a big discussion, open now, also in Italy.
Yes.
So my question is from the last speaker. I just wanted to ask you to say more, to develop your ideas more about how you see big data and technology intruding on religious freedom and shaping our thinking.
Thank you. Well, you can summarize, try to summarize. I think this is, first of all, I think this is a sort of point of attention, I'm saying, is something that we have to careful watch. Because I think we are on the rise of, on a certain, I mean, from a certain point of view, we are still in advance of this phenomenon. But, so my point is this. The question is education, we can say. The big incentive that technology is creating not to educate, that is to take, there is a big, wonderful passage of Thomas Stern Eliot where it says, where is the knowledge we lost in information? That is, I mean, the more we have information, that it not necessarily means that we have knowledge. So my point is that this is a sort of basic prerequisite for every kind of attempt of finding a moral option to your life, or religious or not religious, as we know from religious freedom. And so we can see a lot of signs of this, because I think that the main driver that allows those technological systems to take decisions, to grow, is they are quicker, they seems to be cheaper. So they are moving into sectors of our life in which we have to take a lot of decisions. For example, I come from justice and those kind of systems, public administration. In those systems in which a lot of decisions had to be made and we have a lot of inefficiency, those kind of answers, technological answers, are spreading in a huge way. So my fear is that moving from those kind of sectors of our society, this type of substitution of our moral freedom could become more and more, a sort of habit. And I think that religious freedom, as we were talking now, so for example, think about, before in the previous panel, we heard about why China is deciding to have its own internet. And I think that this doesn't mean necessarily for, even if there is a big US audience, that the US internet is better in sense that also the US based or the other Western big tech based internet has its own interest. And this is the point. Not specifically, as we as constitutional lawyers, we always fear that the role of big tech or platforms is that they can shape or orientate or affect the belief or the decision in a certain direction. For example, certain political party. No, I think there is the hidden and the most basic interest of those systems is simply to keep you attached. It is to stay the more there. on that. So they probably will provide you the idea that you already have. And in this sense, I think that the consequences can be hugely destructive on those issues.
Would it be fair to say that, to rephrase what you're saying, is a major concern with the technological society we're living in is that it's going to make people unreflective, ignorant, manipulable, and passive? Okay.
It's I don't know. It's in the Catholic Church there has been forever a strong respect for the role of women, of course, but the Church is reluctant to have women in the hierarchy. So this is a fact. No, and I think that this is something that goes back to the tradition, and that we have to respect in the looking at the different charisma that women and men have in the church. You don't have to forget that the first person Jesus met when he was living again was Maria Magdalena, so a woman. And so I think that this role of the woman is not diminished in not being part of the hierarchy, but it is the opportunity to deepen your own mission and our own charisma, which is a very terrible risk our society is running, because now the real model is a masculine model, and women have to adapt to the masculine model, and this is not positive for the self-integration of the human person.
I think we have time for one more question. No. Okay. I think that we're done. Oh, there's another. Professor George? Okay.
I got to talk last time, so I was holding off, but if no one else has anything to say. I just wonder if the European participants and other participants from outside the United States might be interested in knowing a little bit about the development of American conscientious objection law, which was really formed around the question of military conscription and pacifism. And this has led to what I think, and what you may think, is an interesting tension, or perhaps even contradiction, in American constitutional law. And it has to do with the question Stefan put at the beginning of the question section, and that is religion something special? Now, as you know, we have no established church. We have a constitutional prohibition on a national established church in the United States. However, when the courts confronted the question of conscientious objectors to military service, of which we had many traditions, Quaker, Mennonite, and so forth in the United States, the law was formed statutorily to require that there be an actual religious basis for the conscientious objection. So it's the reverse, actually, Professor Violini, of what you were talking about. You needed a religious basis for it. And of course, eventually that presented the question, it happened in the context of the Vietnam War, early in the Vietnam War, of what about the person who is not religiously affiliated or considers himself a secular person? Is he excluded from the right? Can he be compelled against his conscience to serve in battle, to serve in combat in which he may be involved in killing? And here what the court did was interpret the law broadly so that the term religion in the statute was interpreted to include what the court called secular humanism. fine as far as it goes, right? I think most defenders of religious liberty would say, well, yes, secular humanists, they respond to the same sorts of questions that religious people respond to, and of course they have the protection of religious freedom, as do others, which is fine. But remember that we also have the prohibition on establishment of religion, the so-called Establishment Clause of the Constitution. And then the question naturally arises, if secular humanism is a religion for, is regarded as a religion for purposes of the free exercise of religion, religious freedom, then shouldn't it also be regarded as a religion for Establishment Clause purposes, which means could the courts strike down certain governmental policies as reflecting secular humanism in the same way they could strike down certain policies as reflecting Catholicism, Judaism, Islam, or whatever it is. And that tension has never been resolved in American law. It's still there. So we still treat religion as the only valid basis for conscientious objection. We interpret it very broadly, but we interpret it differently for free exercise than for Establishment Clause purposes, despite the fact that the word religion appears only once in the relevant clause of the Constitution. It's the very first words of the very first amendment to our Constitution. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, the thereof clearly referring back to religion. So how can religion mean two different things when it's referred to only one time?
Thanks for that
Okay.
comment. Yeah,
Okay, finish. Okay.
it's very helpful.
So we can discuss this further. Thank you.
Please join me in giving the panel a round of applause.